take one of these provisions out, then it appears that's exactly what's happening.
Well, Your Honor, yeah, that's. I agree with you completely on that. The Jordan case, however, did present a situation where the ballot initiative had some applicability and some non-applicability. It had been too broad in what it covered, and so the court chose to assume, let's say it that way, that the people wanted it to apply where it could apply. I think I'm paraphrasing a little.
Well, it was unlawful for it to apply to some offices, if we use the word unlawful, because that's the situation we have in this case, where Metro has said all 5 provisions are unlawful. But let's say if the court determined that 4 of the provisions in this case were unlawful, then you're asserting to just take out the 4 that these petitioners may have all signed up and wanted it to be submitted on the ballot, and just leave 1, and that might be about the parks, wouldn't be about the bonding, it wouldn't be about the property tax. How do we know that the folks who signed this wanted all of them, or just wanted the one about the property tax, and that's why they signed it? Wouldn't I be violating their intentions and their First Amendment rights?
Well, you know, I do have that concern, and the part of why I raised the issue of ripeness is that I believe that should have been a threshold determination by the Election Commission, and then the court should have been in the position to review that decision. We're not in that situation, and I do agree, Your Honor, that this puts there's no case like this that I could find that talked about a multi sort of issue. I don't have the answer to it. However,
so your fallback is severability. Your first thing is, even if all 5 provisions are unlawful, that this should be submitted for a vote. And then your second position is, well, you don't go with that, Judge, then there's always the ability of the Election Commission and the court to sever some of these out that are unlawful.
I think a better way of characterizing it, Your Honor, because of course we don't think they're all unlawful, but if there is going to be a vote, because some part of it is some provisions are lawful, that this court should do the least harm to the ballot initiative as possible. And whether the court determines that means excising a part that it thinks is improper, or allowing it to be voted on in whole, and then a post-litigation determination be made that, hey, by the way, that one provision is not legal. There is plenty of case law out there in these cases about allowing the vote to go forward unless there's no circumstances in which it could be permitted. The wisdom of these decisions, is not to be issued here. So because we ran into this question.
So in a moment, we're going to get to the argument about, are each one of these provisions obviously and clearly unlawful? We haven't gotten there yet, but okay.
I'm just saying that if we reach the point where we think that there is, you just froze on me, Your Honor, I'm sorry. Your Honor, you're frozen. And Mr. Seaman just disappeared. And
Chancellor Law just froze on me as well. So Chancellor Law, if you can hear me, if you'll just stop your video for a second, hit the stop video button, and then we may have to pause just a second. She may have to exit and come back in. There we go.
How was that? Am I back? Am I back in action here? Okay.
Yes.
You're telling me if I freeze. All right, go ahead, Mr. Roberts.
So, excuse me. So, Judge, I don't have the simple answer to the severability question.
I don't want a simple answer. I just wanted to know if it was inconsistent with your previous position, and I think you've told me that it's somewhat of a fallback. So I now understand how that fits. Okay, what's your next argument?
All right, Your Honor. So as we look at the form, as the city of Memphis directed us to, again, there's city of Memphis talks about form. And yesterday, we got into a discussion in the opening statements about subject matter review. And I believe it was Ms. Bustle talked about that a good bit as it relates to the Burnell case in the city of Memphis. And I think obviously that needs to be addressed. So first of all, the city of Memphis case is not about a subject matter determination. It is about whether the way that opinion is written by the Supreme Court is it talks specifically about the form and the facial unconstitutionality. And the question has to be, what did they mean by the form? I mean, it's a very legitimate question. What do they mean by that form? And when we look at the opinion itself, I'm just going to flash it up on the screen here real quick, because I think it's important. In some ways, it was not clear. We often quote the red underline here, the phrase, while pre-election challenges the form or facial constitutionality of referendum or right, for judicial scrutiny, that's what we say a lot. But if you back up a little bit and you look at the Brown case and the Burnell, and we take it back a little bit, the Supreme Court says, rather, Brown presented the concrete and right question of whether the ordinance had been passed and the form, and form is italicized, necessary to legitimately invoke the referendum process. And that's following that is when the court says it's quote about facial constitutionality and free being right for judicial scrutiny. I'd like to address the court or point the court to below that is where it makes the reference to Mr. James Gordon's article about pre-election judicial review. And then it cites, Your Honor, the Burnell case.
Right, which I have read all of these, Brown, Notre Dame, Law Review, and the Burnell. Okay.
Those are good treatises. I've read them both as well. But I would like to draw the court's attention to the very last sentence here. It says, explaining and applying this rule. Okay, so it is the Supreme Court is referencing the Notre Dame article, and it's referencing Burnell as explaining this rule. And I think it's a legitimate question to say, in the context of the Supreme Court's ruling, what do they mean by this rule? Because the city of Memphis case does not talk about subject matter jurisdiction. It's never brought up specifically. And so I think it's a very fair question to say, where is the subject matter jurisdiction being discussed? In fact, I could not locate a single case in Tennessee that talked about subject matter analysis as it relates to pre-election challenges. I couldn't find a single one. I don't believe the other side has quoted any cases. And so if this court is going to bring in a new standard, we need to make sure that this is really supported by this and clearly supported. If you look at the Brown case, well, actually, let's start with Burnell. If you look at Burnell, Burnell was, as you know, was addressing two issues. It was addressing procedural and technical requirements, and it had a clear subject matter restrictions that were being placed. The Brown case, however, was a purely technical issue. It had to do with whether the bill's caption met its body. And so when we look at, the Supreme Court refers to Brown and says form. So that's obviously referring to the form, the structure of the bill itself. And it refers to Burnell as implying this rule. I would submit, Your Honor, that when it says explaining and applying this rule, it must refer to the rule previously announced. And that rule previously announced had to do with technical forms, i.e. the Brown case as the caption meet the body, or facially and unconstitutional challenges. There's nothing in this section of the case or anywhere else that suggests that the Supreme Court was meaning to say, I'm looking at a form question, a technical form question, and I'm looking at a facial unconstitutionality question. And by the way, you should just assume we mean a subject matter question at the same time. I would submit that a fair reading of this does not suggest that the court should do it. Now, would the Supreme Court determine otherwise in the future? Possibly, but that's not this case, and they haven't done it in 16 years. And I understand, and I even accept at some level the reasoning of the Burnell case in West Virginia. I don't know anything about their constitution or their laws or their legislative history or any part of their judicial process, but to take a secondary reference in a case in another state and to imply that the Supreme Court has set that as the standard for Tennessee is simply just not warranted in this situation. That is a huge intellectual jump. But for the fact that the Supreme Court clearly indicated it is explaining and applying, we wouldn't know for sure. But the fact that it really says explaining and applying has to relate to the form, the technical form of the Brown case and the technical form of the Brunel case, because that's the only thing that's the same and that's the only thing that's being applied. So following up with Brunel, and I even went as far as to shepherdize Brunel, and Brunel has never been cited in a case. Actually, I should maybe rephrase that. It's been cited in 2 cases. City of Memphis was one, and the other is O'Kelly versus Cox out of the Georgia Supreme Court, where it's cited in a dissent, and again, applies to procedural and technical issues. The Brunel case has never been cited for a subject matter case. And I would submit that this City of Memphis falls into that category of not being cited for that reason. As the court knows, shifting gears a little bit, as the court knows on this Metro and Davis County, Election Commission, they are the ones attacking this and they bear the burden. And they're going to have to show that each one of these provisions or the provisions entirely, that there is no way that it could ever be legal. And, when there's ballot initiatives, Your Honor, the presumption of favorability must prevail. We know that from the Lockhart case that's cited in our brief, the Jordan case that said that there was the obvious intent of the terms that the county officials to be limited to the extent as possible. There was great deference to the provisions. Excuse me. And in the Jordan case, it said if a provision can be legitimately construed in a variety of ways, it is the court's duty to adopt a construction which will sustain the statute and avoid that constitutional conflict. It is if the citations permit such a construction. Excuse me. So let's look at each one of these provisions, Your Honor, and I disagree with the interpretation placed on them by the Election Commission and Metro. The Tennessee property tax repeal provision or the repeal provision. It's not a repeal provision, it's a rate provision. It says what the rates can be at a certain point. The Tennessee Constitution does allow for property, taxation of property, and delegates that right to the states. Okay. The state grants Metro the power to tax under Tennessee Code 7-2-108. I don't think there's any dispute on that. Metro refers to, and their legal opinion, Section 7-2-108A, which is, he says, the proposed metropolitan charter shall provide, and it has all the creation language. What is not cited by Metro at any point, I can show the court, is further down in this code section is a very clear statement. The metropolitan charter may provide for annual assessments of real property. And so the legislation creating Metro and giving Metro its power, I should say, and giving it the power to tax says that the charter may provide for the assessments of real property. And I would submit that that power delegated to the charter and the fact that the people can amend the charter certainly gives a facial ability of the people to affect the tax rates. Now, I know that they're going to argue that's not accurate, but we're looking at a facial unconstitutionality here and a facial violation of statute. And clearly the Tennessee legislature has said that the metropolitan charter can, in fact, affect tax rates. I suspect Metro will refer to the Tennessee Code annotated 63-53-105. And this is an interesting homeroom municipality provision. That section, relied heavily upon by Metro, says that the state government may, by ordinance, propose to amend the charter related to property tax rates. And that's draw this court's attention to that, and is that this is an ordinance provision. This is a state law that relates to how tax rates are done by ordinance. It is not what the people in this case are doing. The citizens referendum provision is not an ordinance. And so that particular statute, which they rely heavily upon in their legal opinion, relies only to, or applies only to Metro Council and not the citizens. There is nothing in Tennessee Code 6-5-105 which prohibits the citizens from advancing an amendment to amend their charter consistent with Tennessee Code 7-2-108 and affecting the tax rates. Interesting, although not, I don't believe cited in their brief, is the fact that, I'll pull it up here if I can real quick, it's my last exhibit, Your Honor, is that in their own legal opinion, they admit that the citizens have referendum power. And I'll show the court. In a footnote to their opinion, Your Honor, they cite the Attorney General opinion 03-019. And this is an opinion that came out long after these statutes were passed. And they say very clearly, at least it's the Attorney General's opinion, and I've underlined it in blue, that a home rule municipality may amend its charter to provide for the procedures by which a city tax rate may be increased. Well, that's exactly what we're doing. That's exactly what the intent of this ballot provision was to be. It was to set out a procedure by which the city tax rates can be increased. And in particular, it says a home rule municipality may amend the charter to require property tax increases to be approved by referendum. Well, that's exactly what we're doing. This is not original thinking on my part. This came directly from this opinion. And then on page 2, it says, I put a little star next to it, the property rate is one example of a tax to which such charter amendments could apply. Now, much like Metro Legal's legal opinion, the Attorney General's opinion is that an opinion. But when we're looking at this as whether it's facially unconstitutional, and we have the Attorney General of the state of Tennessee clearly articulating that the citizens have a right to set tax rates by in their charter, by charter amendment, then it becomes, I would submit, a little difficult to say that it is facially unconstitutional. And if this provision does meet constitutional muster, and it would even survive a post-election challenge. But it's certainly not suitable for a pre-election challenge where we are today. Secondly, Your Honor, and we would ask this court to take judicial notice that in November 2006, the citizens actually placed a property tax referendum on the ballot, and it was approved and never challenged by Metro. And it became law in 2006. It is section 6.07. It actually replaced the original 607, and it sets a limitation on the level of tax rates. It sets a dollar figure of how high the tax rates go. Now, it was not triggered by the council's actions this year, but there is already in the charter an unchallenged tax rate limitation put on by the ballot initiative and the citizens. Now, it doesn't say they can't, much like our petition, it doesn't say the tax rates can't be higher than the rates as they were as 2006. It says there has to be a public referendum. Again, this referendum, this ballot petition looks at the charter and adopts its language and its permissive authority to go forward. We would submit, Your Honor, that is just one more reason that this provision is entirely appropriate. It's legal, and it certainly is not facially or subject matterly unconstitutional. The second provision, Your Honor, is the land giveaway. And Metro relies upon the Tennessee Constitution, which says no respective law or law impairing the obligations of contracts shall be made. It does say that, Your Honor, and that has been interpreted by courts to mean that you can't take property except under certain circumstances. It doesn't mean that you can never take property. It seems that there is an analysis of how property can be taken. And so if we look at section 21, following that, it also says, no man's particular services shall be demanded or property taken or applied to public use without the consent of his representatives or without just compensation being made, therefore. So we have an interesting provision, Your Honor, that says under certain circumstances, property will be taken, but those circumstances have not occurred. They may never occur. And so it is purely speculative that they will occur. So not only do we have a provision that may not be improved by the voters, we also have a provision that may not ever occur. And we also have a provision that, at least facially, does not violate the Constitution because property can be taken. And whether just compensation would have to be made, I guess, is more of a legal question than a constitutional question. This has been interpreted also, Your Honor, or would lead us, I should say, into a factual determination. If this Metro proffered two contracts as its proof, I should say, of that this amendment would apply retroactively. But that's not the only example or the only end of the analysis, Your Honor, because you have to prove more than just that a contract existed. You have to prove that the contract was impaired. You have to prove that there's changes in the substantive legal changes. You also have to prove that the rights under that contract have vested. It is a factual inquiry that has to be made, that may never be made. And when it's made, all of those things will have to be determined. The question of vesting is probably most prominent because the contract with Belmont was not entered into until after the signatures had been verified on the petition. The contract was not approved until September 30th, well after, and with full knowledge that this petition had been verified and was heading towards a vote. Whether this impairs the contract, whether taking with notice, all becomes a factual issue because it relates to the vesting. The fairgrounds leases were signed weeks after the ballot initiative process began. The same question, where are those rights vested? Will they be vested? Will they be impaired? Those are all factual inquiries that have to be made and will hopefully never be made. And so to say that this provision facially invalidates or violates the Constitution is just simply not accurate. The Constitution does allow property, and so a property to be taken. And if it were taken, it only requires that just compensation be made. And if the property reverts back, they have to make compensation. That's all it requires. The fact that it's an automatic reversion doesn't make it improper because all that is required is that just compensation be paid. And so it's not facially invalid and should be allowed to go forward. The issuance of bonds, Your Honor, we will concede that we were not able to get enough signatures for this provision. It had been thought we would, and next time we may put this as a separate provision. I would submit that the solution, if the court allows this to go forward, as we think it should, at worst, there should be maybe a notation or a limitation that it only extends to the extent prevented by law. I think that's how a post-election challenge would be interpreted based on the Jordan case. But it's really a question of should the court excise that at this point? And again, I don't have an answer for that. I wish I did. I could not find any law to that effect. The next provision is the failed promises provision, Your Honor, and this also contemplates events in the future, and any opinion that this court would render would simply be an advisory opinion. What is interesting about the failed promises, Your Honor, that language was taken from an existing Metro law. Metro Ordinance 1291 had an amendment to it with language almost identical. And so that language was the law of the land, and all the citizens decided to do was take that law and codify it in the charter. Now, that law was later repealed, but it was repealed long after the charter process had initiated. And so whether the vesting of rights has occurred or not may be something that has to be legally determined in the future, but from a facial challenge, it is not impermissible. It just may never happen. And for those reasons, we think that provision does meet constitutional muster, does meet all requirements, and should be allowed. And so I disagree with that any of those are illegal or improper. The last provision, Your Honor, and almost the most surprising, is about the Public Records Act, or the Tennessee Public Records Act, often known as the Open Records Act. Metro claims confusion about this, that people don't understand it, but its own legal opinion, it seems to understand it very well. Title VII is Title VII of Tennessee law. It's the only section of Tennessee law that deals with public instrumentalities or directly with public instrumentalities. It didn't seem that confusing. The ballot initiative proposes on its face to be consistent and construed consistent with Tennessee law. Metro cites no law not allowing, I should say, people to strengthen a public interest law like this. I mean, the Open Records Act, oddly enough, I had a great deal of difficulty finding a Supreme Court case that interpreted what the purpose of this was. It seems sort of obvious that the Open Records, people often quote that it's a good idea, keep an eye on it, or Justice Brandeis, sunshine is the best disinfectant. I was really only able to find one or two cases that defined, and the Johnson versus State case defined it, that said the purpose is to promote public awareness of the government's actions and to ensure accountability of government officials and agencies by facilitating the public's access to governmental records. And that is Johnson versus State. It's a 2016 appellate case from the Criminal Court of Appeals. But it is Metro's argument that this provision is contrary and repugnant to state law, when in fact all it does is make sure that the Public Records Act applies to all the public instrumentalities of the city, and ensures that if the government fails to provide those records, that it will face an increased punishment. No dispute about that. The idea was to increase the punishment for failure to comply. Metro cannot cite a single case that says that the people are not permitted to strengthen a public interest law such as this. It's just not. All the cases cited by Metro are where the law contradicts, or in their words, repugnant. I think they used the word, the exact phrase they used were that this law, that the citizens were prevented from enacting laws or adopting ordinances, quote, adopting ordinances which infringe the spirit of state law or repugnant to the general policy of the state, end quote. I think it is significant that Metro believes that strengthening the Opening Records Act infringes upon the act and is repugnant to the policy of the state. I would submit, Your Honor, that it's the exact opposite of that. That all this amendment does is strengthen the Open Records Act for the people. It pays additional punishment. And this is for a reason, Your Honor, for anyone who's ever litigated Open Records Act litigation, they've been dissatisfied with how this litigation has gone. And so they wanted to strengthen this. And I know that no cases are cited that say that it cannot be done. And again, since the obligation is here, the Metro bears the burden of proving that it can't be done, we would submit that this provision should go forward. So taking together, Your Honor, we don't agree that all of these provisions are improper or illegal or facially unconstitutional. And we believe that the form, as it relates to a subject matter analysis, we do believe that that is not warranted under existing law, and that to read the city of Memphis case to open up a new avenue of attack against ballot initiatives from the people is simply just unwarranted. We would hope that this court would read city of Memphis in the way that we have proposed, and that the application and explanation referred to in that case is only to the form and in a technical sense, because that is consistent with that language, and allow these provisions to go forward.
Let me ask you a question, Mr. Roberts. If the home rule law that you cited to does not apply in this situation, how does that change that argument?
Which rule, Your Honor?
The home rule statute that you cited to, if that does not apply, how does that change your argument?
well, there were several home rule. Are you talking about?
It was the first part of the ballot initiative where you argued that and you showed the court a statute, and I'm not sure that that applies. I'll have to research that. But what I couldn't tell from your argument is whether that's the bulk of the argument or if you have a fallback. If I determine that statute doesn't apply, then do you have a fallback argument, or is it fatal to your argument if that statute doesn't apply?
I want to make sure that we're the home. Are you talking about 65? I'm trying to flip to it here.
Sure. Let me see if I wrote a better note on it so I can give you. You had talked about 6353-105, and then you had also talked about, 6-5-105. You've given me some different sites there, but what I picked up on was when you argued the home rule. I'm going to have to track that down, and I needed to know, is that the premise for the argument, or if we eliminate that statute and that part of the law, do you have a fallback argument?
Okay, and I'm with you. To be second there, I apologize.
Sure, yeah, take your time. I didn't want to interrupt and ask at the time, so I thought I would let you go through all 5 provisions and then back up here.
Let's back up a little bit. 63-53-105 is a home rule provision. It is actually cited in Metro's brief and their legal opinion, and it is, they cite it by citing the fact that Metro is exempt from it. But it is actually a 2-part section. There's a part A and
that was the root of my question. If it doesn't apply, i.e., to use your word exempt, then how does that affect your argument?
So where we go with that, Your Honor, is that the A section is for non-metro. The B section, it says an except for, and it goes through how the Metro Council through ordinance can do certain things.
And you've asserted that this is not an ordinance, so it doesn't apply.
Right. It's not an ordinance, it doesn't apply. And that opinion is, again, affirmed by the Attorney General in the 2003-019 opinion, where they say the same thing, which is that doesn't exclude a referendum by the people. And so I would submit that the Metro is conveniently interpreting that section to mean that it only says that only the Metro Council can set tax rates. It doesn't say that. It just says that's how they do it.
I see. Okay. So the home rule aspect of it was just how you get into it, and then you acknowledge that we're exempt from that, but then you narrowly look at the ordinance part of it. Okay. All right. I understand your argument on that. Anything else that you want to present to the court at this time? You've used about an hour of your time. If there's more, that's fine. I know you want to save some time for a reply, so you tell me how you want to proceed.
Actually, Your Honor, and truthfully, I'm almost finished. So, actually, I am pretty much finished. I tried to do this quicker. Those elements, Your Honor, swing back that this is the burden is on Metro here. The citizens have done all that they were required to do. I believe that strongly. They looked at it, they read it, they signed it, they mailed it in. If there are to be new requirements in Section 1901 in the Charter, then they need to be requirements going forward, not applied retroactively. There's just no basis to do that to the people, to not allow them to follow the rules and harm them. Metro bears the burden of proving the technical problems with the form. And again, I think they follow the form, and with the facial unconstitutionality, which they really honestly haven't put much effort in. I believe that all of the effort put in by Metro was to argue the subject matter. And maybe this case will rise and fall on that, Your Honor, whether the court will extend City of Memphis through the explaining and applying and into Brunel and into other cases. We obviously asked the court not to do that. But all of these things, Your Honor, again, were done with the intention of affecting the government. I mean, I think it was telling yesterday that Miss Bustle, made the statement that this, and very emphatically, that this will harm the past, present, and future Metro government. I could hear people cheering out on the streets on that. That is the absolute intent of this, not to harm, but to affect. And if the government interprets a loss of power as harm, I can't stop them from feeling that way. But it really, truly, unequivocally is an attempt to restrain the metropolitan government. I make no qualms about that. It is to limit the taxing authority as permitted and as the Attorney General says we can. It is to limit the giveaway of property at less than fair market value under certain circumstances. Absolutely. These are things that the people perceive are wrong with what's going on with the metropolitan government. And that's why we have a ballot initiative system. That's why we have a referendum system. It's why we don't live in Venezuela or Afghanistan. We live in a civilized society. But this is the exercise of political force. Just like every time we go to the ballot box, it is political force. It's not a nice way of saying it, but it really is. And so this is the people. The harm that Metro seems to think it's going to have is of its own doing.
Mr. Roberts, when you're finished, I do have a question I need to ask. You tell me when you've completed your argument. I don't want to interrupt, so let me know.
So we want the people to have their right to vote, Your Honor. I would submit that the proper resolution on this, if the court doesn't send it back to the Election Commission to make a decision, if it makes the decision for the Election Commission, then it should put it all to the people to vote and allow post-election challenges to be made if necessary. It may not pass. No guarantees that it's going to pass. I suspect the metropolitan government will spend millions of dollars to try to defeat it, and it may be defeated. Not every ballot initiative passes. But at this stage, pre-election, pre-voting, this court has a heavy burden to deny the people the right to vote. And I hope the court will not do that. Thank you.
And let me explore the limits of that with you, Mr. Roberts, so I can understand what your position is. I need to understand the scope of it. So we know under Tennessee law that election commissions are set up to secure, preserve, guard the purity of the ballot. And they do that for the people, because what we want the people to have when they vote is a clear, pure process. And that comes from the statute, the purity of the ballot. That's their job, that's their duty. When we started this case, Dean Koch posed the hypothetical. He said, suppose there were a drafter, someone who drafted a referendum, circulated a petition, got 27,000 signatures that said only men can run for mayor. Is it your position that we would have to put that to the people for a vote?
No,
we know, of course, that is illegal.
That's the
so I want to start with that premise. So if we start with something that is dramatic, sensational, obvious. If we start with something like that, then we can use that for me to understand at what point do you assert that it's not proper for a court to say, we're not going to put this before the people. So let's start with the Dean Koch hypothetical. Is it proper? No, let me rephrase that. Does the Election Commission have the power, and does this court have the power to take a referendum such as that one that Dean Koch made up, that hypothetical, and put that to the people when it is clearly and obviously unlawful?
And I would say no, Your Honor, because it is the words you used, clearly unlawful. It's not really unlawful, it's unconstitutional. I guess it's unlawful. It's also unconstitutional.
Unlawful, yes. And it would not be consistent with the purity of the ballot that the Election Commission is to put before the people to give them something that is clearly unlawful, correct?
I agree with that, Your Honor.
Okay, so that standard is one that you accept and agree to.
Well, I want to be careful that the fact that I agree with that premise does not mean that it's Tennessee law. And that
well, then you need to explain that to me, because you're telling the court that under Tennessee law, something that is clearly unlawful, as the hypothetical that we're working on, that neither the Election Commission nor this court has the authority, the power to not put that before the voters. Now, remember, we're talking about the purity of the ballot. I mean, Tennessee law set up the Election Commission so the voters aren't required to have the expense nor have something put before them that's unlawful like that. The purity of the ballot. So explain to me, when you say no under Tennessee law, explain your position on that.
Well, I am confident that if that question were to be placed on the ballot, that there would be judicial review and it would go all the way to the Supreme Court.
No, that's not. My question is pre putting it on the ballot. Is there a process where the Election Commission has the authority and this court has the authority to ensure the purity of the ballot and say, we're not going to put something that's clearly unlawful before the people. We're not going to require that expense, and we're not going to do that to the voters, because the Election Commission has the job, the duty to ensure that the ballot is pure?
And Your Honor, I think the answer to that question can be found in the clear reading of City of Memphis, which is, if the election under current law, as I see it written in that City of Memphis and the Littleton case and the case that followed it, that if the Election Commission made that decision, they would be invading the providence of the judiciary by making a legal determination, and that would be improper.
Mr. Roberts, you said in your brief that this was a simple issue, a simple question, and I'm asking for a simple answer. And my question pertains to the standard under Tennessee law. I've read the law. I see what the Election Commission's job is to ensure the purity of the ballot. If we have a clearly unlawful initiative, the question is, do they have the power? Does the court have the power to say, no, we're not going to go through the expense and also do this to the voters when it is clearly unlawful?
Well, that is what City of Memphis says. If it's facially unconstitutional.
Okay, so we do have circumstances where the Election Commission or the court, putting it on the ballot, pre-election, can say this is unlawful, what's being proposed, and there's not to be an election on it.
Well, and Your Honor, I guess my struggle.
Yes or no? Yes or no? Are there circumstances under which the Election Commission and the court can do that?
But I struggle with the
petition formats attached to his letter. Mr. Roberts then set out developing a timeline for the commission's information. The commission held a properly noticed public meeting on September 25th, 2020. The transcript of that meeting is Exhibit 8 in this record. Both Mr. Jim Roberts and the interested members of the public attended this meeting and were permitted to address the commission at some length about their support of the petition. But then it's important to note in that transcript at page 14, line 18 through page 15, line 2, Mr. Jim Roberts told the commission this, quote, "I wanted to be very clear to the commission that the language used on this ballot initiative was crafted over about a 10-year period and that every word was chosen intentionally. It says amendment, not amendments for a reason, and it was absolutely intentional. And it is our expectation, and I'm speaking on behalf of those 27,000 voters who signed these petitions, that it be placed on the ballot as written. It was done intentionally. It was not done by accident." After those comments, the Election Commission then had a lengthy discussion regarding what Commissioner Delanis referred to as the thorny issues before the commission. And the commission reviewed 4 options. The first was to approve the petition and place all 5 items on the ballot. The second was to remove a possibly invalid item, which apparently Mr. Jim Roberts has now conceded is invalid, and place the remaining 4 items on the ballot. The third option was to decline to place any of the items on the ballot. And the fourth option was to file a declaratory judgment on an expedited basis. One commissioner moved to remove one of the 5 items from the petition and place the remaining 4 on the ballot. That motion failed for a lack of a second, page 73, line 16. Another commissioner expressed a preference to decline to place any of the items on the ballot, but there was not a motion to that effect. Finally, another commissioner moved to file an expedited declaratory judgment action, and that motion carried by a vote of 3-2, not unanimously, as Mr. Roberts told you earlier. Far from shirking their responsibilities, the commission's discussion reflects their concern that they had no legal yardstick to measure the scope of their discretion to review this petition for form, facial legality. The commission clearly understood it could not decide substantive constitutional questions and didn't try. But the important thing is, as the transcript shows, the commission was not finished. Because they desired to maintain the ability of the registered voters to vote on this petition if it was found to be legally valid, the commission discussed setting a date for an election in the event the court found that the petition was legally sufficient. The commission staff had prepared a timeline to acquaint them with the steps needed to hold that election. That's reflected in Ms. Hertzfeld's comments on page 76, lines 1-6. And what Mr. Jeff Roberts told the commission was, even if we don't have a final court decision, we can start some of the pieces, put those in place so that we can begin moving along to be prepared for whichever way the court may go. Mr. Jeff Roberts then recommended that the commission should adopt the December 15th as the date for election, page 90, lines 21 and 22. He added, quote, "If we would start putting things in motion, so if you set a conditional date of December 15th, we would be working toward that date, knowing that date now makes it more likely we will have a successful election on the referendum." With that information, the commission voted unanimously to conditionally set the referendum date for Tuesday, December 15th, 2020. That's page 92, lines 10-12, and page 93, lines 1-13. So far from doing nothing, a fair reading of the transcript of the commission's September 25th meeting shows that the commission decided to pursue a declaratory judgment and to set an election date on December 15th conditionally. The only condition was the possibility that this court would find that the petition was invalid and not subject placed on the petition. Other than that finding, the process has started. So as a result of this action, Your Honor, is not necessarily going to be required to order the commission to hold an election if you determine that this petition satisfies the legal requirements to place on the ballot. Mr. Jim Roberts also appears to question the right of the commission to seek a declaratory judgment. And while we've already addressed this question at some length in our trial brief, permit me to repeat that the Tennessee Supreme Court has given its imprimatur on the use of a pre-election declaratory judgment proceeding to address legal issues affecting the ballot or election itself. And again, I'm referring to Shelby County Commission versus Turner, decided in 1988, and Cummings versus Beeler in 1949. Your Honor's comments yesterday that Metro Charter Section 1901's directions regarding the referendum process were cryptic tells me you already have some appreciation for the quandary the Election Commission found itself in. Neither the General Assembly nor the Metro Council has provided clear, understandable guidance for the exercise of the Commission's discretion. In the absence of this guidance, it is difficult to criticize the Election Commission for seeking judicial assistance. Let's face it, as soon as this petition was filed on August 26th, litigation of some sort was inevitable. It was not lost on the Commission that no matter what action it took on September 25th, a lawsuit would follow. The Commission decided to advance the process by filing an expedited declaratory judgment action. And in fact, I suggest that this course is the most efficient, linear approach to resolving the myriad of legal issues surrounding this petition. It will avoid bouncing the case back and forth between this court and the appellate courts and the Commission, just as what happened in the litigation between Mayor Ron Littlefield and the Hamilton County Election Commission that ended up making 2 trips to the appellate court before it was resolved. Were this case remanded back to the Election Commission either to place the petition on the ballot or to reject it, can there be any reasonable doubt that the Commission's decision will be again challenged in court on essentially the same issues that are currently before Your Honor now? I think the answer to that is there is no reasonable doubt. So thank you again, Your Honor, for your consideration of the Commission's arguments, and I welcome any questions you may have.
I do have some questions, and it pertains to this last part of your argument. And please understand on behalf of the Election Commission that I'm not being critical of them when I ask this question. The root of my question is Mr. Roberts' challenge on his motion to dismiss that this case is not ripe and it's not justiciable. And so that's the basis for my question. While our charter, section 19.01, is cryptic, as we've said, we know from the case law that the Election Commission does have some discretion when it comes to the form of a referendum. Mr. Roberts conceded that. It's stated in the City of Memphis versus Shelby County case that we're all using here, 146 Southwest 3rd, 531, and you have alluded to that as well, Dean Koch. We know under that case that election commissions can look at the form and make a determination without going to court on whether a matter should be placed on the ballot. In this case, there have been discussion about the form. You started with that, calling it a political document. We know that it also has some marketing type things in it of bolding. The captions are political, not substantive. We don't have citations to the place in the charter that it's amending. So there are definitely a number of form issues. Why shouldn't the court remand this matter back to the Election Commission? They're the ones who have the expertise as an administrative body on how things are put on the ballot and the form, and have them make a determination, at least on that sliver of it, put aside things that pertain to substantive constitutional issues, but require them to take the next step and with their expertise, make a determination whether the referendum complies in form with what is required under Tennessee law.
I appreciate your question, Your Honor. And the first thing I would note is that form is in the eyes of the beholder. As you'll see in the transcript, the commission was having a difficult time knowing what the term form includes. You'll see that they wrestled with that question. We think the rightness issue is squarely addressed in the Turner case in Cummings versus Beeler, where the court said that there's sufficient adversarialness between the parties, and as long as that exists, the case is ripe to be decided before an election. I think
when I heard your argument in that comment, what comes to mind is the declaratory judgment standard that says if you have a controversy, you don't have to get to blows, so to speak, but you can bring it into court if it's sufficiently ripe. In your answer, if you can filter what you're saying through that declaratory judgment standard, because that the parties have all, sought a declaratory judgment from the court, and that's a standard that I would use. But I am concerned about the fact that the Election Commission does have authority with respect to form issues. And Mr. Roberts has said, what kind of precedent will it set if election commissions just run to courts every time they have an issue like this? So sorry for interrupting, but if you would, I wanted to ask you to envelop in your answer the declaratory judgments standard.
Sure. And if I understand the force of your Honor's question, I'll answer it and you tell me if I'm responding directly to what you want.
Okay, thank you.
The declaratory judgment statute also refers to the right, status, and other legal relations. So we think the statutory definition of declaratory judgment is broad enough to cover this claim.
Okay.
If we're addressing specifically rightness, I would suggest that we go back and look at City of Memphis versus Shelby County Election Commission. And with all deference to my dear departed friend, Justice DeWoda, a lot of the language that you've been parsing and we've been discussing might be considered dictum in that case. That really what was before the court in City of Memphis was a referendum that was intended to place allow the City Council in Memphis to impose a professional privilege tax. And the challenge to that referendum was that the city had no authority to do that. When Justice DeWoda was trying to sort all this out, his rightness decision with regard to the court and I assume the commission was first, it's not all that clear that this is ever going to happen.
Right.
But then what he pointed out was, yes, it might go in the ballot, it might get defeated, but it might pass. The city council in Memphis might never pass this ordinance, even if they're given the power to do it. And then on top of that, the legislature might even give them the power to do it before they do. So there were 3 or 4 levels.
Yes, and we've had the argument by Metro that this is self-executing, the referendum. So are the facts that important, that distinction? Because we've used this case quite a bit.
Well, I think the factual distinctions are very important because the fact that if this referendum were put on the ballot and if it were enacted, it goes into effect immediately and creates, as you referred to, a domino effect of problems down the road. And I wish I could point, Your Honor, to a statute or a rule or an ordinance that guides the Election Commission's exercise of what you're referring to as its discretion over form, but this is completely uncharted waters. Again, these commissioners are not, you've referred to their expertise. These are not people, we have 2 laypersons, we have 3 lawyers, none of whom have written treatises or law review articles on the nuances of election law. They are people doing the best they can to interpret the cryptic language that is presented to them. And they basically said, we don't know how far the form issue goes. We don't know the scope of that. And secondly, we're not entirely sure, and this was with reference to Mr. Delanis' proposal about elision, that it's not entirely clear to us that we have the authority to do it or whether we even should. So I wish the commission had a better playbook. If they had a better playbook, this case would be here perhaps in a different posture, but we don't. And we're looking to the courts and to you to provide some guidance about how we should do our job. And certainly if Your Honor remands this back to the commission with a discussion about what the scope of their authority is with regard to form, the commission is not going to ignore, Your Honor. Now, your decision may be appealed, and then we get into that issue, but if the commission is tasked with that job, with Your Honor's instructions, the commission will do it. I'm just humbly suggesting that that process will not add any more to the record, will not provide any more law or facts that a court is eventually going to need to either go thumbs up or thumbs down on the legality of this petition.
So in terms of sending it back to the commission, as Mr. Roberts has asserted should be done, he said that the court should enter an order immediately, have the commission meet immediately. With respect to that, you've asserted, one, it's not going to add any value to the case, any more information, any more insight, any more facts. And then secondly, you assert as a matter of law that the commission had the right to come to this court and seek a declaratory judgment under that declaratory judgment standard that we have, the status of the parties, the legality, etc. So as a matter of law, the court can go in and decide it and is not required, as Mr. Roberts has asserted, to send it back to the commission, get them to act, and then bring it back to court.
Now, a smart advocate would say, yes, Your Honor, you're entirely correct.
No, if there's a caveat, I need to know it, so please add it. That's why I ask these questions. I don't want the amen chorus. I want you to dispute me if there's a problem in there, please.
There is absolutely no problem with what you said. Here's what I would add. The city of Memphis case makes it very clear, if there's one thing clear about Justice DeRota's opinion, the separation of powers prevents election commissions from reviewing the substantive constitutionality.
Yes, that is very clear. Yes.
But the city of Memphis opinion does not say that the courts cannot do that, because that is what the power of the courts include.
And
so
in fact, it talks about the three branches of government, and it does talk about the court's role. Okay. So where are we headed with this?
So the only point I'm making is that in addition to issues involving the form or the facial properness or constitutionality, the issue of the substantive constitutionality is teed up for you, and you can address those questions as long as there's not a ripeness problem, which we assert there's not.
And that's where you and Mr. Roberts very much disagree. Okay. All right. Anything else, Dean Koch, on behalf of the Election Commission? This will be your last time to speak in the case. So if there's anything else you want to say, this would be your opportunity.
Those are very comforting words, Your Honor.
The pressure's on. Anything else?
I have nothing else. Thank you.
All right. Thank you very much. At this time, we will take a break. We'll come back at 11 o'clock, and at that time, the court will hear from the Metropolitan Government, who will be presenting the argument on their behalf.
Your Honor, I will be presenting the closing argument.
All right, Mr. Cooper, then we'll start back at 11. Thank you
Very
all.
good.
Mr. Seaman, if you can put us in our break rooms, please.
All right, court is in recess and I've opened up the breakout rooms. I will bring you back into court at 11 o'clock. everybody back from the break. So court is again in session.
Thank you. This time the court will hear the closing argument of the Metropolitan Government. Mr. Cooper, if you are ready to proceed, let me see if you are muted. Yes, there we go. All right, thank you. If you would begin.
Very good. Thank you, Your Honor. Bob Cooper, Director of Law for the Metropolitan Government of Nashville and Davidson County, making the closing argument on behalf of the Metropolitan Government defendants. Let me add my word of thanks to what Dean Koch said. We very much appreciate your getting this matter heard on an expedited basis. It is a case of great public significance, and we appreciate the way that you have handled it and brought us to this point. Your Honor, there are legal guardrails that apply to the referendum process in Tennessee. Certain basic requirements that have to be met to put a referendum petition on the ballot. And these are guardrails that protect Metro government, its citizens, and the integrity of the process, the purity of the ballot. These are guardrails that this court can and should enforce now pre-election. And Your Honor, as we have seen over the course of this trial yesterday and today, For Good Government's petition goes far outside of those guardrails. The proof at the trial showed beyond doubt that 4GG's petition is deficient in form in at least 3 ways. It fails to comply with the procedural and technical requirements for a referendum. It involves subject matters beyond the scope of the referendum power. And it is not drafted to convey a reasonable certainty of meaning so that a voter can intelligently cast a vote. In addition to those defects in form, the petition is facially unconstitutional. On its face, it violates the Tennessee Constitution's prohibitions on respective laws and impairment of contract, on taking property without just compensation, and waiving sovereign immunity. Now, Your Honor, all of these under the City of Memphis are deficiencies that this court can consider now. And the provisions of this amendment are not severable. So a defect in one provision is fatal to the entire amendment. Now, if we wait until after the election to fix this, great damage will be done to Metro and to public confidence in the referendum process. Now, Metro government supports the Election Commission's request for a declaratory judgment. We think its complaint is ripe under Cummings versus Beeler. But even if the court were to conclude that the Election Commission could not bring these claims, we have filed a separate complaint for declaratory and injunctive relief. And Your Honor, for the reasons we'll discuss, we think that that complaint is justiciable and ripe. So let me deal with that issue up front. Metro government is asking for 2 things: a declaratory judgment that the proposed amendment is defective in form and facially unconstitutional, and an injunction prohibiting it from being placed on the ballot. We have standing to bring these claims, and they are justiciable. Now, if the amendment is put on the ballot for December 15, the following will happen. The election administrator has testified that this election, this special election, is going to cost, at a conservative estimate, $800,000. Metro pays that sizable bill. That's under Tennessee Code 2-12-109A1. And as the proof is shown, we've already appropriated $3.1 million to the Election Commission in the current budget. That's Exhibit 32, page 14. This extra $800,000 would require a supplemental appropriation by the Metro Council, which is going to increase the total appropriation by over 25%. And if the amendment is void ab initio, that is wasted money. Now, under Cummings versus Beeler, that by itself is a distinct and palpable injury that is sufficient to establish standing. But the harm of putting this amendment on the ballot is much, much greater. First, property tax bills went out this month, and taxpayers obviously are confused about what to pay and when to pay it. Second, the amendment is self-executing. It takes effect immediately upon approval, requires no additional action by the council or anyone else. That is joint stipulation of fact number 7. And in that case, Metro will face an immediate and totally unnecessary financial crisis. Metro will lose at least $332 million in budgeted property tax revenue. That's Exhibit 46, page A2 in the mayor's budget book. Losing that much money will obviously have a wrenching effect on Metro's budget and operations. And the Metro budget at that point will be in violation of state and local law. It will be unbalanced, in violation of Tennessee Code 9-21-403 B and C, and it will violate the Metro Charter sections 6.03, 0.06, and 0.07. In addition, Metro will be in breach of bond covenants, leases, and other agreements, as I'll discuss later. Now, all of this financial chaos can and should be avoided when an amendment is clearly invalid like this one. And finally, Your Honor, there's the harm to the public confidence from having citizens vote on an amendment that is clearly invalid. To cite some cases from other jurisdictions, it would force voters to give their, quote, time, thought, and deliberation to a referendum for no reason. That's the South Carolina case of town of Hilton Head, which is cited in city of Memphis. And this situation led the Southern District of Ohio to conclude that repeated votes on matters unlawful or unenforceable on their face could erode public confidence in the entire initiative or referendum process. That's Schmidt versus Husted. Both of those are cited in our brief. So, Your Honor, with this extensive impact on the Metro government, fiscal and otherwise, Metro clearly has standing here. So let's move to justiciability. There really should not be any dispute over this, and I'm going to share the screen here. Okay, trust you can see that.
Yes.
We've talked a lot about the Supreme Court's holding in the city of Memphis, and that holding could not be clearer. And pre-election challenges to the form or facial constitutional validity of referendum measures are ripe for judicial scrutiny, pre-election challenges. So let's talk about those concepts before we get into the evidence. As you can see, this opinion, the city of Memphis opinion, cites Burnell as, quote, explaining and applying this rule. Well, what is the rule that they're explaining and applying, Your Honor? It is that language highlighted there. Generally, it's the general rule that they're talking about here. It is not the previous Brown decision. It is the general rule that pre-election challenges to substantive constitutional validity are not right, but pre-election challenges to the form or facial constitutional validity of referendum measures are right for judicial scrutiny. So plaintiff's restricted reading of City of Memphis and Burnell just doesn't hold water. In fact, his concession that his petition does not have enough signatures to satisfy the Local Government Public Obligations Act means even he accepts a broad reading of Burnell. So let's see what Burnell says. Okay. Sorry about that. Burnell identifies two types of defects in form. First, procedural or technical requirements incident to placing the measure on the ballot. Now, what are those? Well, some of those are in section 19.01 of the charter. Number of signatures, filing the petition with the Metro clerk. But Your Honor, that is not the only source of technical requirements in the law. State law imposes technical requirements. And the Local Government Public Obligations Act is one very important source of those obligations in this case. And the proposed amendment flagrantly ignores that act. Now, the second type of defective form is subject matter. What is that? It's whether it involves a subject matter that is beyond the scope of the referendum power. And so what are examples of subject matter restrictions? Well, section 19.01 contains a subject matter restriction, which is that referendums are to be used to amend the charter. There is no provision in 1901 that allows a charter referendum to be used to pass or repeal legislation. Now, other subject matter restrictions are found in state law. Again, the LGPOA prohibits referendums for certain types of bonds, a prohibition that this amendment ignores. And these subject matter restrictions do not have to be expressly stated in the law. They may arise by implication. That's the state ex rel Childress case, which is also cited in the city of Memphis. So here the facts show that the proposed amendment violates subject matter restrictions on bonds, on taxes, and on public records. Now, Your Honor, we would say that there's a third requirement of form. It's not mentioned in Burnell, but it does arise out of state law. And that is that what appears on the referendum ballot must convey, quote, a reasonable certainty of meaning so that a voter could intelligently cast a vote for or against. And that's from the Rogers versus White Supreme Court case of 1975. Now, when you review the incomplete, ambiguous, and argumentative language in the petition and the proposed amendment, you can only reach one conclusion, that there is no certainty of meaning about this amendment. And voters could not possibly know what they are voting on. So those are defects in form. Now, also under City of Memphis, facial constitutional validity is ripe for pre-election review. City of Memphis doesn't define the scope of this area review, but Tennessee law generally defines a facial constitutional challenge as one that must establish that there's no set of circumstances under which the act could be valid. And in referendum cases from other jurisdictions, pre-election judicial review of facial unconstitutionality has been allowed where, quote, the issue of law raised is so clear or settled as to constitute matters of form. That's the state versus state ex rel Hazelwood case, also cited in City of Memphis. Your Honor, we would say here that the proposed amendments overreach and retroactive application make it clearly violate multiple provisions of the Tennessee Constitution. So, Your Honor, we think that's the legal framework here. And with that, let us get into the specific provisions of the proposed amendment. We're going to start, since there's been a lot of discussion of it, with the issuance of bonds. And Your Honor, we have a chart here, just kind of a scorecard to help the court, where we've broken this into columns and rows with regard to the types of defects that are present with this amendment. And here we're talking about bonds, which really covers the waterfront of all types of defects. It violates technical form, it violates subject matter, it's facially unconstitutional. And Your Honor, the general form we'll get to later and handle that as a whole at the end. So what is the bond language here? That requires that all bonds issued or guaranteed since January 1 of this year, so this is retroactive, exceeding $15 million for a specific project must, with limited exceptions not applicable here, must be approved by voter referendum. Your Honor, let's compare that to the technical requirements of the LGPOA in Title IX, Chapter 21, Part 1, et sec. Now, Mr. Roberts has repeatedly said we're nitpicking here. The LGPOA is critical to the financial health of local government. In fact, Your Honor, it, as Ms. Bussell told you yesterday, It is the intent and the purpose of the act to provide a uniform and comprehensive statutory framework authorizing local governments to issue these bonds, which are critical to their operation. And in fact, this is so critical that the LGPOA preempts all local laws to the contrary. Restrictions or procedural provisions contained in any other law or any home rule charter, notwithstanding any other provisions to the contrary, are not enforceable under this act. So, what are the mandatory steps to bring a general obligation bond to the market under the act? Well, Your Honor, here they are. Local governing body adopts an initial resolution to issue the bond. The resolution has to be published in full in the local newspaper. Then if someone wants to protest the bond, they have to file a petition within 20 days of the publication of official notice, and it has to be signed by at least 10% of the registered voters liable to be taxed for the bonds, which in Metro is the entire county. So this is a technical requirement that, if a valid petition is not filed within 20 days, then under the act, no election is necessary. And there's a subject matter restriction here, Your Honor, under this act, because no election is necessary if the bonds are for waterworks or sewerage purposes, or if the governing body determines that an emergency exists. That's both of these requirements are in section 9-21-207. Now, so you got technical requirements under the LGPOA, you've got subject matter requirements under the LGPOA, and the proposed amendment throws all of these requirements out of the window. It does not require that a petition be filed to protest a particular bond issue. It doesn't require that a petition be filed within 20 days of public notice. It doesn't require that a petition be signed by 10% of the registered voters in Davidson County. It does not exempt water and sewer bonds or emergency bonds. Instead, almost every bond in issue in Davidson County is going to be subject to an automatic referendum based on a petition signed by far less than 10% of the registered voters in Davidson County. And we have the testimony from the election administrator that establishes that. So the 4GG petition doesn't even try to meet these technical and subject matter requirements for a bond referendum. And this is nicely illustrated by exhibits 34 and 35, which is the 2020 water and sewer bonds. And mind you, Your Honor, this is just an illustration. Those bonds were issued on April 8th of this year. They're for over $215 million. They are for one purpose, and therefore they fall within this amendment, even though water and sewer bonds are exempt from referendum under the Act. So this is a clear violation of both the technical and subject matter requirements under the Act. Another good example here, Your Honor, that Ms. Fussell provided to you yesterday is in Exhibit 36, the bond anticipation notes. Now, bond anticipation notes are also covered by the LGPOA. That's in 9-21-501 at SEC. They're a form of financing where Metro issues interest-bearing bond anticipation notes to raise capital for any purpose for which bonds could be issued. And the notes will be paid at some point in the future by issuing bonds. Now, under the LGPOA, local government goes through all of the bond issue steps: the resolution, publication, 20-day time for protest, before the notes are issued. And the notes create a contractual agreement with the note holders. And in that contract, Metro is representing that it has complied with all of the LGPOA statutory requirements. Now, the LGPOA doesn't require additional notice, and it does not allow protest later on when the bonds are issued to pay off the notes. But under the proposed amendment, Metro will have to hold a referendum when it issues bonds greater than $15 million to pay off these notes. Again, these are clear defects in the form of the proposed amendment, violating both the technical and subject matter requirements of the LGPOA. Now, Your Honor, we think that these form defects by themselves are enough to reject the issuance of bond provision. But in addition to these defects in form, the provision is facially unconstitutional. Article 2, Section 20 of the state constitution prohibits retrospective laws or laws impairing the obligation of contracts. You can't use legal changes to take away vested rights or impose new obligations on existing contracts. So let's go back to those 2020 water sewer bonds, Exhibit 34 and 35. Metro made multiple representations and warranties to bondholders in those bonds, including that Metro had the full right, power, and authority to issue the bonds under the Act, under the LGPOA. Bondholders now have a vested right for repayment, but the proposed amendment imposes a new retroactive limit on Metro's authority to issue the bonds, and that impairs the bondholders' vested rights. That same constitutional defect occurs with the bond anticipation notes. In fact, it's going to be true for all bonds and notes issued since January 1. In sum, the issuance of bond provisions is in all respects defective in form and facially unconstitutional. Let me move on to the next provision that we want to discuss, Your Honor.
Let me ask you a question about the bond provision. So you argued with respect to how the referendum provision on bonds is not consistent, doesn't comply with the LGPOA statutory scheme here, and you concluded that argument by saying that that was a matter of form, that under our City of Memphis case, we have a problem with a referendum that doesn't comply in form. Can you just tie up the ends on that? Why do you say that not complying with the LGPOA constitutes a violation of form by the referendum?
Certainly, Your Honor. The question of form, and it's two parts here.
You talked about subject matter, yes. So delineate that for me. Go into that, please. We had procedural, and then we had subject matter. Yeah.
Right. The procedural and technical issues go to how many signatures you need for the petition.
Right.
And when the petition is filed.
Yes. So is this a subject matter situation?
This is both.
Okay.
That under the LGPOA, you have technical requirements about when a petition has to be filed and how many signatures it has to have.
I see. Okay, I'm following you now. Okay, because you're talking about item 3 here. Yes. So item 3, those procedural requirements you say do not comply. Yeah. Okay, I'm with you now. So if we take the referendum and we compare what it states and we look at this item 3 here that you've pulled out of these code sections, then I see what you're saying. It's a different procedure. So that's the procedural defect. And what's the subject matter defect then?
The subject matter defect, Your Honor, is that the LGPOA says that there are just certain bonds that cannot be subject to a referendum.
Oh, yes. Okay, that's the water and sewer, and that's your last bullet point on that. Okay, good.
Water, sewer, and emergency bonds.
Good. I just wanted to go back to your outline where you had talked about form and there were the different aspects of it and see which one of these they fit within. Okay, thank you. All right, we can move on to the next provision of the referendum if you're ready to do that.
Yes, Your Honor. And let's talk about the property tax provision. Here, Your Honor, we're going to discuss both procedural and technical form defects, subject matter form defects, and then again, we'll save the general form for later.
And before we get into this argument, let me go on and tell you something that the court needs you to address.
Sure.
Mr. Roberts had mentioned this in his argument, and then also we've had an amicus curiae brief filed in the case. And in that brief, it's argued that what we have is a cap, a limitation here. It's just a cap that we don't actually, we're not setting a tax. And then the other matter, of course, was that 2006 referendum that we had here in Metro. And Mr. Roberts has raised that argument as well as the amicus curiae brief. They've said that the position that Metro is taking in this lawsuit contradicts the fact that we had a referendum in 2006 when Metro says that we're not allowed, or that this referendum would violate a number of state laws. So if you'll weave in a response to those arguments for the court as you're presenting this.
Sure. In fact, let me deal with them a little bit up front, and then go into our argument.
Sure.
But first, let's talk about the 2006 amendment to the Metro Charter, which does put a cap purports to put a cap on the property tax rate, which can be exceeded by referendum. Your Honor, that was passed in November 2006. Metro Legal issued a formal public opinion a month later in December 2006, in which Metro took the strong position with significant analysis about why that provision was unconstitutional. And that has been Metro's legal and metropolitan government's position since that time. The reason it has not been challenged in the intervening time is that such a challenge has never been right. Metro has never come close to that cap. In fact, Metro government's property tax rates have been historically low over the past 15 years. And so there has been no occasion where the issue would have come into play. Obviously, if in the future, if that became a ripe issue, then it could be brought to this court. But simply the fact that it is part of the charter has no precedential significance here, Your Honor. And certainly no estoppel. Metro has been clear about its position on this amendment ever since it was passed. Now, it is a cap, and the amicus brief that you point to, just try to draw a distinction between a cap and setting the rate. Your Honor, respectfully, that's a distinction without a difference. And we will talk about this. The point is, it is the authority to set property tax rates has been extended by the General Assembly solely to the legislative body. And any infringement on that is contrary to the express direction of the legislature. And in fact, the case on which the amicus brief relies, quite interestingly, the case from Maryland, the Anne Arundel County case, involved a provision with just that sort of cap, cap on property tax rates that could be exceeded by a referendum vote. And the court held that the provision about allowing it to be reviewed and raised by referendum was a violation of the state law, which in Maryland similarly conveyed the right to tax property to the local legislative body. The opinion said submitting property tax increases for referendum approval meant, quote, in essence, the voters would be setting the tax rate for that year, close quote. And since that was outside the grant of state tax authority, the court struck down that requirement. So even their own case doesn't support the constitutionality of the property tax provision here. Let me step back here, Your Honor, and talk about what this provision does. It says that property tax rate shall not increase more than 2% per year after January 1, 2020, again, retroactive here, without a voter referendum. The council set the property tax rates in June as required by law by passing the property tax ordinance, which is Exhibit 33. And according to the mayor's budget book, that increased the property tax rates by 32%. That's Exhibit 46 at A7. So there is no dispute here, obviously, that the property taxes increased more than 2% after January 1 of this year, the threshold in the property tax provision. And so there is no dispute. In fact, it is featured prominently in the petition itself that the proposed amendment will, quote, repeal, close quote, the property tax ordinance. And in fact, that's what it does by backdating the effective date to January 1, 2020. Your Honor, respectfully, this is not how our tax system works. These property tax rates were passed in June. They took effect in July when the new fiscal year started. They became due and payable in October. Bills were sent to county taxpayers in October. Late penalties accrue in February. After February, they are projected to generate $332 million in revenue on which Metro's current budget is based. That's Exhibit 46 and 32. We will be almost halfway through this fiscal year before this referendum is scheduled to occur. So 4GG wants to change the rules in the middle of the fiscal year. This is not only irresponsible, it is unnecessary because there are multiple defects in form of this amendment. First, setting property tax rates is a subject matter beyond the scope of Metro referendum power. And that is clear from the plain language of state law. We've cited the statutes in our brief. General Assembly, which and all taxing authority of local government can only come from the General Assembly. Has extended property tax authority only to county legislative bodies and not the public. And we have cited those statutes to you in our brief. Now, Metro, of course, also has the power of cities. And the General Assembly has allowed home rule municipalities, as Mr. Roberts said, to set the property tax rates by a charter amendment referendum in 6-53-105. But, as the court pointed out, Metro is specifically exempted from that statute. Now, Mr. Roberts says, well, this is a narrow statute that only deals with ordinances calling for a tax rate referendum. But, Your Honor, that misses the point. Local governments only have the taxing authority explicitly granted to them by the General Assembly. Now, the grant under 6-53-105 is limited, and Metro doesn't even enjoy that grant. So, Your Honor, Metro does not have authority to do this by referendum under state law. Now, Your Honor, we would say that second defect in this proposed amendment, the tax provision, is that it attempts to legislate by referendum. In fact, it repeals legislation by referendum. Metro Charter only provides for a referendum to amend the charter, not to pass legislation. So by seeking to do this, the petition is not complying with the technical requirements under Section 19.01, and it exceeds the permissible subject matter for a referendum. And both of those defects in form are reviewable by this court under City of Memphis and Burnell. Now, legislating by referendum is common in other states or other jurisdictions that have detailed procedures for how to do this. But Tennessee is not such a jurisdiction. There's no legislating by referendum in the Tennessee Constitution. There's nothing in state law that allows this except in very limited circumstances. The LGPOA, which we've already talked about, liquor retail sales, annexation questions, local sales taxes, E911 districts. And we have cited to you the Bean versus City of Knoxville case. So some municipalities have legislated by referendum, but only where the state legislature and the municipal charter both authorized it. And we don't have that situation here, Your Honor. The Metro Charter Act, the state statute, doesn't allow legislating by referendum. It says that the Metropolitan Council, quote, shall be the legislative body. That's TCA 7-2-10811. And the Metro Charter does not contain any process for legislating by referendum. Now, the amicus brief says that the Metro Charter could have such a process under Section 3.01. We disagree with their interpretation of that, but there is no dispute that there is no language in the charter now that allows this. So, Your Honor, the third problem with this property tax provision is that it's not just trying to legislate by repealing the property tax increase, it is trying to do that in the middle of the fiscal year. And that is not only irresponsible, it is illegal. Even the Metro Council doesn't have that authority. We have cited you several Tennessee Attorney General opinions pointing out that a county legislative body cannot alter the county's property tax rates in mid-fiscal year. If the Metro Council can't do this, neither can a referendum. So, in summary, Your Honor, the tax provision is defective in form, both technical and subject matter. Excuse me. So, Your Honor, those two provisions, I think, required some fairly detailed discussion. I think we can move more quickly through the other three sections of the proposed amendment. We're going to go to the failed promises section. Now, Your Honor, very simply, this section is facially unconstitutional. By its plain language, it will deprive Nashville's 4 sports teams of all of their contractual rights and business interests if they leave Nashville or cease playing professional games for 24 months. Now, there's no grandfather clause here, Your Honor. Under either circumstance, all the facilities and related commercial development will revert to the people, and all related contracts will be terminated, including land leases from the Nashville Fairgrounds. So, Your Honor, the council said yesterday that, of course, you can't you can't affect existing contracts like this. That would be an impairment of contract. Well, Your Honor, that is exactly what this provision does. There is no exception here for existing contracts. It will be an impairment of existing contracts, and it will be a taking without just compensation, no compensation under the state constitution. Now, as proof of this, we tendered the lease agreements between the Metro Sports Authority and Nashville's professional sports teams. Those are all in Exhibit 37. We also tendered the intergovernmental project agreements supporting those leases between the Sports Authority and Metro government. That's in Exhibit 38. They're all long-term leases. They all spell out each team's rights and obligations. They specify the revenues that each team will receive from the venue and the uses they can make of each venue, both for athletic and non-athletic events. And there is nothing in any of these agreements that allows termination based on the terms contained in the proposed amendment. Rather, this proposed amendment imposes new conditions on existing contracts if the teams don't play for 2 years or leave town. Now, that's taking a valuable property right and is facially unconstitutional.
Mr. Roberts made the argument yesterday that, and I just want you to go over it one more time. You addressed it, but I want to make sure I understand your position. He made the argument yesterday that just obviously this would not apply to these existing agreements that we have. And I studied the wording yesterday. I'm studying it now. Do I understand it to be Metro's position that there's nothing in the wording of the referendum, the failed promises provision, that indicates there's any kind of grandfathering? Is that your position, that it's not set out in the text? And if that is your position, what is the law with respect to presumptions or other matters that leads you to be able to argue, well, this would cover all of our sports teams here in Nashville?
Your Honor, I think you just look at the plain language of the amendment. And the plain language of the amendment is applying to all sports teams, regardless of when they arrived in Nashville, regardless of when their contracts were executed. It's just very simply, if a professional sports team leaves Nashville or ceases playing professional games, then they lose facilities, commercial developments, and contracts.
So the triggering event is just if an existing team leaves or they cease playing, and since there's no grandfathering, if that's the triggering event, then even these contracts entered into prior to the amendment, it's your construction of it, that they would be covered by the referendum.
Your Honor, absolutely. And what's more, that is the plain language reading of this amendment. I think if this were to go before the voters, and certainly I think any petition signer who read this would assume that is what it means. And if Mr. Roberts is going to claim now that it means something else, then that should have been communicated to the people who signed this petition. That should have been communicated. That should be communicated to the voters. But all that goes on the ballot is this language.
So you're saying that this would apply to the Titans, as I remember your proof yesterday, you say Ms. Bussell showed it would apply to the Titans lease, to the Predators lease. We had the MLS lease, and then I guess the Belmont school lease. Okay.
Well, the Sounds, Your Honor. It would also apply to
that's
the
right,
Sounds.
the Sounds.
Yes.
Yes.
This would not be Belmont. Belmont falls under the next provision, the no giveaways provision.
Okay.
But it would apply to the 4 existing sports teams.
All right. And you say that's just the plain, ordinary meaning of this, that a signer of the referendum understood. And that violates, it's unconstitutional. Okay. Mr. Roberts made an argument that you can't say it's facially unconstitutional because there are a number of things that have to happen before this would go into effect. Any comment upon that argument?
Certainly. Your Honor, I think the reason it has an immediate effect on the contract, on these contracts, because it essentially changes the terms of the contracts. It puts new termination obligations on these contracts. That has an immediate effect. That's obviously going to affect operations. It's going to affect business decisions. You can't say that this only becomes relevant if once a team decides to leave, or if it, for whatever reason, pandemic or otherwise, has to suspend its operations for 2 years.
Okay. All right. Is this everything on failed promises, or do we need anything else you wanted to say with respect to that provision on the referendum?
Nothing else on failed promises, Your Honor, but so we'd like to go on to the next provision, the no giveaways provision. And there again, our argument is that it is facially unconstitutional, as well as having general form defects. And there, the language imposes new restrictions on all transfers of real property by Metro, a supermajority vote of council, fair value appraisals, transfers only at market value, but more pertinent to today, it requires a voter referendum for any transfer of real property valued over $5 million or leases exceeding 20 years. And this requirement is once again retroactive to January 1, 2020. So this too, Your Honor, is a facial violation of Article 1, Section 20 of the Tennessee Constitution. It also impairs the obligation of contracts by attaching a new requirement, voter approval, to all covered transactions that have been consummated this year. And there is no provision for just compensation in this amendment either. And the fact that parties can sue for an unjust taking certainly doesn't make it constitutional. And we've provided a couple of examples in the record.
bolding, and then marketing about framing the issue, or is that just not applicable?